Having referred to the pleadings, let us examine what the High Court has held. Full stop. The High Court holds that all successive claims arising under the same obligation shall be deemed to constitute one cause of action. Full stop. It further finds that the crux of the matter is there are two alienations of separate areas of the land on different dates, and although they are in favor of the same parties, it would give rise to more than one cause of action. Full stop. It was further found that by restricting to first suit to the first alienation, it could not be found that plaintiff has split up the claims or split up the remedies. Full stop. The execution of the second shall deed in favor of the same party gives rise to distinctive and separate cause of action. Full stop. The High Court further proceeds to refer to the illustrations in order to Rule 2 CPC, which reads as follows. Full stop. Para. A lets a house to be a yearly rent of rupees 1200. Full stop. The rent for the whole of the years 1905, 1906 and 1907 is due and unpaid. Full stop. A and B in 1908 only for the rent due for 1906. Full stop. A shall not afterwards be for the rent due for 1905 or 1907. Full stop. Para. Thereafter, the High Court proceeds to take a case where a owns two houses and he let them to be. A suit is filed in respect of arrears of rent in respect of one house, though arrears were there in respect of the other house also. Full stop. The High Court takes the view what it is the choice of the plaintiff either to unite or not to unite both the causes of action, and the second suit would not be barred. Full stop. Para. In the case of Muhammad Khalil Khan versus Mahbub Ali Mian, the earlier suit related to the property at Youth. The parties belonged to the Sunni sect and the properties belonged to one Rani who owned properties at Shahjahanpur and Youth. The first suit did not include the property at Shahjahanpur. Full stop. The court proceeded to uphold the wise. It is further stated that the land is to be treated as an ancestral joint family property, and the alienation being not one for necessity or for conferring benefits upon the estate or for payment of antecedent debt, and it is liable to be set aside.